Hello. Hello. Maria.
Hey.
And hi, Alan. Is this Alan?
Yes, this is Alan. Hi, everyone. Hi, Maria. Hi, Linda.
Hey, Alan.
Sorry, we're just about to begin.
No worries.
I was trying to just first add in the speakers. We have too many people who signed up. We tried to upgrade our accounts and we weren't successful because Zoom is overwhelmed. Everybody's getting on Zoom. So I just want to make sure we have first added all the speakers and then we can add in everyone.
Okay.
So we have 300 attendees who registered, but we have only capacity for 100 people.
How many registered?
300.
Wow.
So I'm just trying to add in first the speakers and then I add in everyone else.
Okay.
Linda.
That's fine. Okay. Cool.
Yeah.
You get Linda.
I'm trying to just get her on this. But
You're only on audio.
okay, so I think I'll just add everyone else who's in the waiting room. So we'll begin in a few minutes. That's okay?
Okay.
I'll just add one and then we figure out it. Okay. Everyone
It's starting. It's starting.
Okay. Thank you very much, everyone, for joining us today on our discussion around COVID-19 and the impact that it has on the legal profession. I must admit that we are overwhelmed and impressed by the interest around this topic. And so today we'll be doing this virtually. We were hoping that we could have a lot more people join us today. However, we do not have the capacity to handle everyone who's getting in. And so we are beaming live on YouTube. And so if you want anybody else who's complaining that they're unable to get in on this particular webinar, please just ask them to go on YouTube. Our YouTube channel is Lawyers Hub Africa. And so I would want to first introduce our panelists who will be discussing with us some of these topics, and we hope that we'll be able to engage. If you want to ask a question, we have shared a link that you could ask a question on Slido. Slido is sli.do. Use the hashtag COVID-19 law, COVID-19LAW. If you use that hashtag, we'll be able to see your questions and we'll be able to answer them as we go along. If you can hear me, please just chat on the group chat. Just confirm. Some people say they are unable to hear. Just go on the group chat and confirm that you can hear. Don't ask questions on the group chat because they won't be answered. Okay. Okay, and if you can, please put your mute yourself. Don't unmute yourself in the process of this webinar, unless we ask you to. So yes, if you want to ask any questions, please go on Slido, sili.do. The hashtag is COVID-19 law. And we have a link as well. If you want to be part of the notes that we are taking, we shared a link on your email that allows us to jointly come together, with a document. And so I'd want to just first introduce our first speaker. I'll introduce the speakers first, and I'd ask Maria to go first.
Hi, everybody. My name is Maria Beneka. I'm a council member at the Commonwealth Lawyers Association, immediate former council member at the Law Society of Kenya, where I convened the ICT and IP committee. I'm happy to be here in partnership with the Lawyers Hub. Thanks for having me, Linda.
Okay. Thank you very much, Maria. I'm trying to find Alan. Alan, if you could just unmute your mic.
Great. Thanks, Linda. Happy to be here, colleagues. My name is Alan Maleche. I work at KELIN. KELIN is an NGO that focuses on health and human rights, and I'm also a practicing lawyer on health and human rights issues. Looking forward to the conversation.
Okay. Thank you, Alan. And I'd ask Linda if you could unmute yourself. Linda?
Hello.
Yes, Linda, we can hear you.
Okay, my name is Linda Wambani. I'm an in-house counsel. I work at Safaricom. I specialize in technology law, and I'm glad to be joining this conversation today.
Okay. Thank you very much. And then I'd want to invite Declan to introduce himself as well. Declan?
Hello, everyone. My name is Declan Magero. So my background is in venture capitalism and investment. I sit on the advisory of Lawyers Hub, and I also am a co-founder at Afrinet Capital, which is a venture capital platform. And it's a great pleasure to be part of this discussion as well. Thanks.
Okay, thank you very much, Declan. I'd want to invite Linda, now that we're done with the introductions. Everybody sort of knows what's happening around the world around COVID-19. It's the first pandemic that has happened in this decade. The last, I think Spanish flu was in 1920. And so we as lawyers are, caught up in the middle of all this and wondering how to make sense of it, and also to make sense of it to our clients as well. So we thought as the lawyers have to put together, different speakers from diverse backgrounds to help us make sense of this, and also to chart a way forward, especially on policy, and see what policy interventions we could have, as well as tech tools that we could take up to help us through this particular pandemic. And so I'm going to invite our first speaker to just share their experience. To share the experience on as in-house counsel. So I want to invite Linda Wambani, who just introduced herself. She works with Safaricom, and she's closely worked with the legal space. She's going to, with the tech space. So she's going to also introduce and let us know what she does exactly on that area. Linda.
Thank you, Linda. So what COVID-19 has really, the lesson that really has been brought home is that it's really time for the legal fraternity to embrace technology. We've seen a wide range of cross-legal services severely impacted by COVID-19 and the requirement now to work from home. So in my experience, what I would say is that COVID-19 has been an eye-opener in the sense that we now have to move from the traditional ways of working, which is where you work from a physical space in an office setup, really to start considering ways to work virtually and still be able to deliver services for your clientele within the legal space.
Okay. Are there any tools that, for example, at Safaricom that you are working with? What has the experience been, I think, as in-house counsel? How do you support the entire organization away from home? And are there concerns around cybersecurity as you do your work from home?
So I think Safaricom, I would really say, has been a pioneer in terms of the remote working mode of work, because the entire company has been empowered to work from home. We've embraced tools like Microsoft Teams and Cisco Jabber to be able to connect virtually into the office from wherever space you are at. And then we also have, we use the virtual private network to be able to access office documentation. We have several, we have a fully fledged cybersecurity team, which is enabled to ensure that as staff work from home, the network is secure, and that we would not have security attacks in terms of staff being able to access company documents virtually. Secondly, in terms of the crisis management, we have a end-to-end crisis management plan and business continuity plan developed from across cross-stakeholder management within the company, starting from the legal team, the risk team, the senior leadership team. So we have several stakeholders within the company monitoring the pandemic on a day-to-day basis, essentially to support our staff as well as the provision of service to the country.
Okay. Thank you very much, Linda, for that. In-house counsel may be wondering how to support their organizations through this. Are there any legal issues you see that come up within the organization that if I'm in-house counsel, I'm affected by this, and maybe the organization needs different, advice from me? And two, we've seen a lot of engagement from people who are in litigation, lawyers in litigation, who are, sort of saying they're offering essential services, and therefore the judiciary should not be shut down. What do you make of it?
So I would say that in-house counsel is actually positioned in a way to actually be able to support such kind of crisis. The nature of an in-house counsel is that they should be able to rise up to the occasion in the event of their pandemic. And so how the legal team within Safaricom has been able to support the business is that, first of all, I think we've taken the lead as a department first to enable ourselves to work from home, to be able to continue to provide service to the business. We form part of the crisis management team. And so I would encourage the in-house counsel that there are various ways that you can actually support your businesses in terms of such a pandemic. Specifically that as an in-house counsel, you should be able to assess the legal and risk environment caused by the pandemic and be able to give your company solutions around that. So in terms of legal service provision, you will be looking at your business service provision in terms of what commitments you've made to your clients within the industry. How do you continue to provide service to that? In terms of people, how do you ensure that the corporate staff are secured within the pandemic? How do you enable them to continue to provide legal services in terms of the pandemic? Actually, I would say in-house counsel is instrumental in managing the way the company will respond to the crisis. Because if you look at the in-house role, there are various services which you can provide. For example, there will be need for corporate communication. So you look at, you lead the strategic communication that will go to your internal stakeholders and your external stakeholders.
Okay, thank you very much for that, Linda. I read some judgments, I think from Europe, where a law firm was, there was a cyber attack on a law firm, and the court decided that this was negligence on part of the law firm. And so I think we need to be very careful as lawyers, even as we work from home, that we need to use cybersecurity tools that will ensure that client data is still safe, and that for instance, I don't know how many of us use a VPN, virtual private network, that still allows us to ensure that our clients are safe. Are there any tools that maybe, Linda, you could recommend? You had recommended Microsoft for Teams as a good platform to work together as a team. I think you mentioned something else that I quite didn't get. Are there any tools that you could recommend?
So Linda, I would not recommend the tools, but I would give an example of the tools we use, because obviously if you're sourcing for tools, you need to involve a technical expert, and particularly a cybersecurity expert, to advise you, depending on the scale of your network, what would be the most suitable tools for your business. But as I alluded, what we have internally within Safaricom, we are using Microsoft Teams and Cisco Jabber. to be able to provide, to be able to work remotely. Of course, at the back end, we have several cybersecurity softwares that have been implemented by the business to ensure that there is no security breach in terms of the confidential documents and information that we keep as a business. But probably what I would say for the medium to low to small sized firms, there are still other ways within which you can provide legal services, and there are even online tools which can assist you to do your work. For example, right now we are using Zoom to have this virtual meeting. Zoom is a good way to be able to meet with clients and to have a conversation without having a physical presence.
Okay. Thank you very much, Linda. Linda Wambani from Safaricom. Thank you for the comments. If you have questions for Linda, please go on Slido, sli.do, and use the hashtag COVID-19 LAW, COVID-19 law. You'll be able to ask questions on that particular platform. If you can't hear us, I think there's a problem on your end. So the best to do is to use your device's audio. Please ensure when you join, you use your device's audio. Next, I'd want to invite Declan Magero, who's part of the advisory team at the Lawyers Hub, to talk to us a little bit about models, because people say lawyers rely too much on face-to-face interaction. And therefore, now that everybody is stuck home, we are wondering how to get new clients, what are the new business opportunities, and also how to support, our networks and our clientele. So Declan Magero, I think you can proceed.
Thank you very much, Linda. Yeah, definitely COVID-19 has presented a critical challenge to global economies, and of course the industries, especially let's say the legal industry. So from where I sit, I love to investigate business models and how they could be adapted to various kinds of situations. And by the way, this is not the first time the world has been through some kind of crisis like this. The world has potentially seen worse. I think most law firms are, in my opinion, caught up in what I can call a traditional business model, where it's a partnership model and then you have associates, and your revenue model is usually billing clients, either consumers or firms. I think this is the general framework of most law firms. But I think it's about time that law firms change a little bit the business models to focus on things, or even think about things like breaking even, because I'm not even clear if law firms are sustainable as businesses. I haven't seen law firms technically reporting their numbers. So I think I don't think the traditional law firm model is necessarily built to scale. And the law firms that have scaled had to tweak their business sort of company structures rather, in order for them to be able to scale. I think one way that law firms could actually adapt themselves to this kind of situation is by thinking about some very basic things. Like, are you, as a law firm, are you just an advisory, or do you also offer, or do you have a product-based approach, to market, as well as, let's say, a service-based approach, service delivery-based approach to market? For instance, if you design a service delivery process, then it will be pretty clear to you, one, to define the kinds of services that you actually offer to the market and best ways to reach clients. The other way is a product-based approach would be you'd actually think about yourself as a product company and devise some products that potentially could be you're offering to the market and to your clients. This potentially will change a lot of things, how a traditional law firms can actually operate. You'd have a real product that you can actually price and people can subscribe to or buy almost upfront. So that's one way of thinking. Another way of thinking is your service delivery process. Traditionally, I think most of it is face-to-face, and that's why I usually joke that every lawyer must have some little corner office with your ugly name embossed on it, in gold. I don't think this has to be necessarily the approach. The approach can automatically change in the sense, with use of technology, you can reach more people right now. you can offer some of these services to a lot of people without caring for your little office or little space where you exist. So if this was an approach that, let's say, a law firm had actually adopted, then this COVID-19 crisis could not be like a real shocker, because you can still engage with your clientele very, very comfortably. I think another angle that law firms can actually look into is the industries and sort of how they approach these industries. My opinion is most law firms, if I can use the term subjective, are a little more subjective than objective in terms of approaching the market. And I'll give a critical example. Most law firms do not look at public good as a potential market. And I think if a law firm had its eyes on the public good, and I will run a quick example on this, then it has the potential to have a lot of impact in this period. For instance, the whole issue of businesses collapsing and startups dying in this period is actually something pretty serious. And if you look at the numbers, about $83 billion have been pulled out of the African market by investors right about now. How do we fill this kind of gap? One way that I believe law firms could actually play in this space is, for instance, by looking at pension funds, which is technically a public good. Every single jurisdiction in Africa, for instance, has a pension fund. And for instance, if you take a Kenyan case, in 2015, Kenya government changed regulations to allow pension plans to invest up to 10% of their assets in private equity and venture capital. This is actually a resource that startups and businesses, SMEs, can actually tap into right about now. But I haven't seen a single lawyer or law firm that raises questions around this, and even putting these agencies to task to show us how this is done, or even advising on some of the ways that this can actually be implemented. And this is just one quick example. Another example could be in the health sector. There's the issue of access to healthcare, etc. That is a big deal now. I think this is squarely also, of course, apart from the health sector, it's also something that lawyers can actually come in because it's policy-based. So I think you can also look at the tech industry going forward. So I think it's sort of the kind of vertical sectors, industries that a law firm focuses on is really critical. And that mentality needs to change very, very strongly on how they approach markets. Linda.
Okay, thank you very much, Declan. Nkata asked a question. What do you mean that the ability of traditional law firms to scale? Could you explain what that means? Do traditional law firms don't have abilities to scale? Why? What different methods do they use?
Oh, great. Thanks for that question. So scaling in this case is a question of, if I can say, scope and scale. So scope is technically the number of industries you can approach, the number of markets you can approach. It should go beyond a jurisdiction like Kenya moving forward. So I think the traditional model, as it's designed, the partnership model, based on associates and billing clients directly, does not embrace a lot of critical elements that a company needs in order to scale, to grow in volume and depth. For instance, what I've already talked about, like what are you offering to the market, and how do you design and package it in terms of either service or product? Most of the law firms, I think, from where I sit, just offer more or less the traditional services that are expected, that are already defined by existing laws. But most of them do not take the extra step of being a little bit innovative and approaching certain markets that may need some more work in terms of defining new products, defining new practices, defining new services. So this is one way that, one difference that a law firm can have. The other one is seeking opportunities beyond, for instance, your jurisdiction, and standardizing approach to these opportunities or solutions to these opportunities such that it can cut across a wider, let's say, market. So that means that you can offer a service here, and you can also offer a service in Lagos, for instance, and it's a standardized service that somebody also in Cairo would also need. I think this is more or less how law firms need to start thinking, and that will posit you in this place where you can actually reach out a wider market and target a bigger market. And that will translate back into numbers. How do you price some of these things, some of these products, some of these services? And can you design your whatever you're offering such that it can scale down to real numbers that can actually report somewhere, and one day somebody can actually buy some kind of law firm through an acquisition, or a law firm can get listed on Nairobi Stock Exchange or London Stock Exchange, I don't know. So I think this is the new thinking that needs to be embraced.
I wish law firms could be listed on the stock exchange, especially Nairobi Stock Exchange. That's still not possible. And I think the challenge with the legal profession is that it's highly regulated, and it's been that way for many years. I'm impressed that this few weeks we have had a disruption of the laws that are surrounding how we operate as lawyers. And so thanks, Declan, for that. We're going to have questions at the end, but I'm very happy to have Maria because her video is on. And so Maria, it will be good to see another face on the video. So Maria is the immediate former convener of the ICT Committee of the Law Society. And she is also a council member of the Commonwealth Lawyers Association. And so Maria has had the experience of just walking through the past 2 years on how does technology look like within the legal sector, for the judiciary, and also for the legal profession. So Maria, please make a few good remarks in this regard. I think Maria, I have just unmuted you, so you can.
Okay.
Yeah. Sorry, we can't hear you. I think there's a... Maria, we can't hear you. We can't hear you.
Can you hear me now? Can you hear me now?
Yeah.
Now, great. So thanks, Linda. Like you said earlier, there's been a lot happening in the judiciary that was started a while back. Many of us who've been in the profession longer have seen starts and stops in terms of trying to digitize or improve efficiency in the judiciary. If you remember, GJ Laws was a program that was started to start recording of proceedings.
Maria, you're breaking a bit. So maybe
in the courts. And I remember in court one, when we used to appear before. Can you hear me now?
You're breaking. So
Can you hear me now?
Yeah.
Yeah, now, can you hear me now, Linda?
Yes, I can.
Yeah, so I was saying that we've had some progress. It's been slow, but I'm happy with the progress now that we're seeing. I guess it took a tragedy such as COVID-19 to help us. Now, the judiciary has an integrated court management system committee, which has been doing a lot of work, and that committee is headed by Justice Gatembu. And Justice Gatembu has done a lot of work together with other judges. I remember there was Justice Ocheng in that committee, Justice Jackie Kamau, amongst others, and members of the judiciary. And what we have had, in the pipeline is the commercial division has had a program where we were trying to test what e-filing would look like. I remember as a committee, members felt that it was not proper digitization, which I agree, because then you would have to file manual documents together with the pleadings that you had filed. And of course, there's been a lot of work that has happened since then. And yeah, anyway, there's someone's microphone. So anyway, there's been a lot of work that's been going.
Okay. I think we lost Maria for a moment.
Can you hear me now?
Yes, we can hear you.
Yes. So what the committee has done since then, and I'm happy to report that we did a lot of work. We came up with practice directions. The CJ's practice directions are now ready. We have about 24 of them, these practice directions, and they are quite clear, and they're supposed to apply to all courts. We also have proposed in that committee, we last met in December, just before Christmas, and we proposed amendments to the civil procedure rules as well as the criminal procedure rules, so that lawyers or members of the public can file documents online. And what will be required is that all practitioners will have to get e-accounts to enable you file your documentation. Now, looking at where we are today with COVID, it is important to appreciate that this is going to happen faster, and which is a good thing, because I thought by now we should have been up and running, but we've been forced by circumstances to do so. If you look at there was a circular that was prepared, I think it was yesterday or the day before, by the CRJ, and the CRJ gave the courts leeway within which to apply the CJ's practice directions as far as e-filing is concerned. Now, the bigger question here will be access to justice, especially to those people who do not have access to the internet. That's a big question. How will they do it? Can we have USSD platforms that will allow people even to track their documentation? What kind of assistance is going to exist outside of the judiciary, especially for people with disabilities, people who cannot access the physical courts where they'll have the kiosks, because the proposition is that at the judiciary, especially at the courts, you will have a place, let's call it a kiosk, an e-filing kiosk where you can file your papers. Is this going to be done through Huduma centers? And now with the social distancing and the quarantine and just staying at home, what does that look like, and what does that portend for the court users? So access to justice is a big question right here, especially now that we're grappling with whether or not we are an essential service. And if you look at what's happening in the UK currently, there have been directions by the CJ. The Lord Barnett has given practice directions, especially for existing criminal matters where you have they have their juries who are already in place, and matters that are already proceeding. What happens then? But of course, they have to take cognizance, and members of the public as well as barristers and solicitors have been asked to take note of the Public Health Act, and where it is felt that you may be at risk of exposure, then you do not proceed to expose yourself. So these are some of the issues that, frankly, I feel the judiciary still has an opportunity to address now that we have technology. We don't need to hold matters, especially if you look at plea taking, where you require urgent matters to be filed. We have, as civil practitioners, you have situations where your clients want perhaps even to execute a will. What do you do in such a situation? So as law firms, as the judiciary, as the Law Society generally, and as practitioners, we have an opportunity to harness technology to our advantage. And this we can do with the judiciary as a front runner, but as practitioners, we really must get on board. We have to ask ourselves how many of us have automated, for example. If you look at most of the law firms, I wouldn't say that they've completely shut down. You'll find situations where perhaps it's the senior partners or associates who are working from home, they're able to send in their documents by email. But what's happening to the support staff, for example? Are people still asking their court clerks to go, to the office? Are they attending the registries, for example? And what does that portend in terms of even the employment law, given that we have to exercise caution when we're exposing our employees to some of these vagaries, especially an exposure where you require people to be queuing in a banking hall or so forth and so on and so forth. So various scenarios to look at. I can say that in the Commonwealth, looking at the practice across the Commonwealth, the West has been really affected by COVID. So, the lockdown has happened in the West. So, our partners, even in India, they have just effected the total lockdown. So this issue of accessing the courts is really, has really been minimized. So only those who have taken advantage, those jurisdictions who have taken advantage of digitization and have, been doing it for some time are the ones who are getting some traction in terms of filing their documents or having their matters expedited using technology.
Does it have to take a pandemic for people to get on board? And the background information is that I think in Kenya, we've had this sort of, I'd call it running battles between the judiciary, between government and lawyers. We're supposed to digitize the land registry. We had a problem. We need regulations around it. Even the judiciary coming in online and e-filing, we needed regulations around it. And that takes a lot of time. But just this week, those same regulations were passed. And so what's it with us lawyers? Do we have to have a pandemic to take up technology? What sort of attitude would you advise the lawyers to have, and law firms as well?
I don't think the laxity, Linda, has been on the part of the lawyers, especially when it comes to the government registries. I think there's been a lot of delay on the part of the government. If you look at the run-ins we've had with lands, it started in 2018. When I joined the LSK Council, we had an impasse with the lands ministry, and we've had a myriad of issues with that particular ministry, and even whether or not the Land Commission is doing its work, whether the ministry has usurped the role of the lands, the NLC. Then you've had the e-regulations, which we worked on close to 2 years with the team of ease of doing business. We came up with a raft of suggestions and technical proposals that we gave, and you, Linda, I remember, were a member of the ICT IP committee, where we gave our input on the proposals that were being put forth by the Ministry of Lands. And having worked on those proposals, then those regulations were not passed. So there's been a lot of, I think, laxity on the part of the Ministry of Lands. Even now, remember when we went to court and got an order stopping them from shutting down the registry. Remember, once then it became obvious that COVID was upon us, they quickly ran and said, okay, yeah, then we're shutting down our registry. I think there's been lack of goodwill on the part of lands in terms of trying to improve business. On the other hand, business registration services have been...
Maria, we lost you. Sorry, we lost you, Maria.
Quite efficient. In the beginning, can you hear me now?
Okay, we can hear you. Go ahead.
Yeah. So I'm saying that with the business registration services, on the other hand, it's very easy now to register companies. I know this has been a source of angst for many lawyers who, used to be, in this area of practice, registering companies, so forth. Now people can, go online through eCitizen and do their own registration. But there's an opportunity, if you ask me, beyond registration. There are other services that are required by our clients that don't necessarily have to do with the registration of companies. I certainly have had clients come back to me saying they need one or the other service post-registration. So I would say that in terms of business registration services, there have been opportunities. Efficiency has improved. So it's up to the lawyers then now to look at what opportunities arise in terms of the company law. The Act has changed. It was amended in 2014. A lot of changes have come about since then, even amendments. What are we doing as a profession to align in terms of even digitizing our own offices? And I'll go back to this very important point because a lot of our offices, and I had an opportunity to talk to a lot of advocates when I was going around the last 3-4 months, and a lot of us are still using hard copies for our records, and not many of us have digitized, and it's not easy to keep track even of your own clients and the matters that you have. Many files have gone cold. What they're taking up space, are they pay? Is that file paying for itself to be a file that you're handling? So those who are coming to the profession, there's an opportunity for you to digitize. It's easier, definitely, than it was for us who joined the profession many years ago. And this is an opportunity for you then to harness what Linda is talking about, this calamity. It's forcing us to digitize, but then it's an opportunity then for those who haven't to take advantage and do so quickly. Those who've had files, it will have a cost implication in terms of digitization, because then you have to scan those files, get a system where you upload the files and so on and so forth. But it's easier. It's not all is lost. And as a profession, we can harness the technology that is available to lawyers and techies who can assist with this. And we don't need to reinvent the wheel to be able to digitize. But it is important for us to remember that advocates are required to set up e-accounts so that when you're uploading your files onto the judiciary portal, you have to be registered. Otherwise, then you will not be able to benefit from the service that is being offered by the judiciary.
Okay, thank you, Maria. Thanks for that. I really appreciate. And the fact that as lawyers, we recognize this digitizing begins from, from our law firms, from our everyday life. And so when you start taking up these technologies, it's easy to take up technologies issued by government or other regulators. So thanks for that, Maria. Our final speaker is Alan Maleche. He's won so many awards. Try Google him and you will feel sorry for your life. But we'd want him to just do the connection around tech policy. Kellen has been working on access to healthcare and emergency healthcare. And so COVID-19 sort of opens up our eye to the policy aspect, to the access aspect. So I'd want Alan to just come in and also speak about the work that they're doing, the advisory that they have out there, and how we can engage on this. Alan.
Thank you so much. I'm not one of the lucky Kenyans who got the 4G from Uhuru, so you won't be able to see my video, but happy to build up on what others have been able to say. I think I'll start by thanking Lawyers Hub to bring this conversation on board, and say that for me, the first starting point is to say every lawyer who is keen on the conversation of COVID should look at the following laws: the Data Protection Act, the Public Health Act, the Access to Information Act, and the Constitution. I say this because we anticipate from a health perspective a number of litigations that are likely to stem from there. There are already concerns around how much information is the state providing to citizens on the state of preparedness. Do we know how many healthcare workers are available? Do we know how many test kits are available? Do we know how many people have been tested? Do we know what bed capacity that the ICUs have in Kenya? How many cases we can meet? So there's a deficiency in the amount of information that is available. Yet the Constitution on one hand gives you the right to information. The Access to Information Act gives you that right, but the government is not adhering to some of that information. What happens if you have a client who has disability and says all ways in which the messaging has been communicated has not been suited to them? Would that be a violation of their right? And so those are issues we may want to start looking at as lawyers to see what are the likelihoods of these issues coming after or during this particular period. I think the second law that is critical is the Public Health Act. And many of us are candidates of being in the isolation wards because you never know who could be able to catch COVID. But there's
I'll ask you to shout a little bit, Alan.
So I'll say the second law to look at is the Public Health Act, and many of us are possible candidates of being in isolation wards because we don't know who is likely to get in there. But as you see now, the government has not even told you what does it look like, what do you expect in isolation, and what does that mean for you? And now coming to the Public Health Act, there is actually litigation that has been decided by the High Court. There is a case of Daniel Ngetich versus the Attorney General. I think it's 329 of 2010. And it basically talks about the interpretation of why do you resort to isolation, who is valid for isolation, how do you determine a person is infectious, and what are the steps that lead you to isolating a person. Importantly, that particular decision also compelled the government to come up with an isolation policy. But the irony is that the isolation policy is in place, but all the isolation facilities that have been set up now have not complied with that policy. So if I'm detained in an isolation facility, can I argue that it does not meet the right to health standards? Or if I'm detained in a hotel, is it set up for isolation? Is it contemplated for that? And then in terms of data protection, there have been concerns around in a number of countries where mobile phone companies may, because of the emergency, be pressed upon by the government to have to share private data in terms of surveillance. Whereas in an emergency, those exceptions may arise. But after the emergency, what then happens? Will the government then be able to violate the right to privacy for people? I want to add one last point and then see whether we can converse against other things. I think the challenge that our courts are currently not open, yet we have seen either on social media, the human rights violations that people are facing at the airport when they land, being taken to a hotel for isolation, and if you do not have money, what then happens? So the fact that our courts are not actively open for people to be able to safeguard their rights, and also equally the fact that we actually have ongoing litigation by the Law Society about the fact that the government allowed a flight to come in and there's a risk that was posed to the population, points to the fact that the courts need to figure out during times of emergency, how do they stay open? Whether paperless, whether online, whether technology, we can't afford to have the courts closed. And I do agree with our president, Nelson Harvey, lawyers should indeed be on the essential list because these are the times when violations happen. So my advice and future thinking of litigation would be, after we've won the COVID war, what are some of the litigation issues that are likely to come up when people say, my rights were violated, I was denied this, or this contract was breached, or because of duress, I was put in a situation to sign a contract with a hotel, and now I cannot honor it. So I'd urge my colleagues to also look at it from that perspective and preemptively start looking at what is the possible litigation that's going to stem out of it, but urgently now to see how do we raise our voices as the Law Society or as lawyers concerned about the interests of people, because as of it is now, there are many gaps that are being shown in the way the response is happening. And this is not only unique to Kenya, it's in many countries, and as lawyers, we have a role to play in terms of ensuring that vulnerable access justice, but also that the rule of law is upheld. Over to you, Linda.
Okay, thank you. I'm in Studio B, thank you. No, I'm kidding. So Alan, I have two questions for you. First, for those who are not familiar with the work that Kellen does, you've done some work on HIV/AIDS and also TB. How do you sort of differentiate what you do on a daily and what the pandemic COVID-19 brings in a legal sort of perspective? And two, does Kelin do this across the continent? We have people from Burundi and Nigeria who are also joining on this call. And it would be good to point them either to organizations that do this, especially on the issue of strategic litigation.
So great, I'll start with the last one because it's the easier one. And I think if there are colleagues from Nigeria, there's an organization called Lawyers Alert that we work with closely in terms of matters litigation. I'm happy with organizers to provide our contacts to be able to link you. And for Burundi, we only know individual lawyers, not particular organizations, and happy to connect that. We do work across Africa with partners. We are not physically based in every African country, but we have a number of partners across the board that we work on health and human rights issues. Apologies, I didn't introduce what Kelin does, and I just to quickly say that we are a health and human rights organization that's mostly comprised of lawyers. We basically look at laws and policies. We look at facilitating access to justice. We look at building the capacities of communities to know their rights and claim them. And we occasionally work with duty bearers, judges, lawyers to try and enlighten them on what are the possible issues around the right to health. So on matters on HIV and TB, and if you have a chance to look at the advisory we put out, we are just basically drawing the parallels of what happened when you had HIV and TB epidemics and how human rights were violated and certain approaches governments took that were not working. One of them is basically trying to paint the person with a virus, be it HIV, be it TB, be it COVID. When you paint the person as a criminal, when you paint the person as evil, or when you turn to criminal sanctions to say, stay home, or if you don't stay home, I'll arrest you, or report so-and-so if you see them sneezing, you create a fear. And that from the HIV and TB experience has shown, people then don't come out to test. And so you'll then have more people who have the virus staying in the house because of the messaging of the government, knowing their punitive measures around it. Of course, there may be people who do not want to isolate, and that is an issue that has to be handled on a case-to-case basis. But what we've then seen that has changed is that we are getting a number of people complaining about lack of access to services. People living with HIV are saying some of their clinics are closed and they can't access their medicine. What do you do to be able to address some of those rights? And so given this limited access to the courts now, we've had to turn to writing letters, to reaching out to government agencies, to making phone calls to find out what administrative arrangements can be made to ensure that even though there's a COVID issue, people who still need access to their cancer medicine, people who still need access to healthcare facilities, how is that being taken into account? But I would feel there's a lot the world can draw from HIV, from TB and Ebola in terms of how to deal with emergencies in a way that puts the human being at the center and not just using punitive measures and threats to try and get people to be able to stop the spread of the epidemic. Thanks, Linda.
Okay, thanks for that. I'd want to, maybe my final question on this would be emergency healthcare. The Constitution gives us the right to emergency healthcare, and that has been, I don't know how much you've explored that. If I'm taken from my house because I have coronavirus and I end up at Nairobi Hospital, are they able to treat me, or do I need a deposit of 300,000 shillings to get me on a ventilator? What do you see as the connection between emergency healthcare within the Constitution, I think Article 43, and everyday, occurrences in this case?
So the issue of emergency healthcare is a critical issue. I think there has been litigation on this. For those who may want to check a case called the Alex Madaga case, basically a case that concerned a person who spent over 42 hours in an ambulance because there was no capacity to admit him in any ICU. Now, Linda, can you imagine a situation where you're in a road accident, God forbid, and you're rushed to the hospital right now and you're told because of COVID, we already overwhelmed and all our ICU beds that are not over 100 across the country are already full. Where will you be admitted? Where will you be taken? And again, the whole question around what is the responsibility of government hospitals vis-a-vis what is the responsibility of private facilities, because what we've seen in the past is that many private facilities will decline to take people until a certain deposit is paid. And then what are the rules and guidelines that Parliament has put in place, or the Ministry of Health, in light of the fact that the Healthcare Act says that everyone has a right to emergency medical treatment. So for now, in terms of COVID, you may get the emergency medical treatment because The government has a lot of money, which again, they're not accounting to us on how they're using it. But again, the government is supposed to take the responsibility of taking care of you in terms of COVID. But if it's not a COVID emergency related situation, then there are challenges that come that would have them to be addressed either by litigation or by advocacy in terms of trying to push healthcare facilities to be able to take this forward. And sometimes other colleagues in this forum may be the ones representing the healthcare facility. And so the question would be, what measures has the government put in place for the private healthcare facilities to be able to offer emergency medical services without the fear of running down on their costs of being bankrupt because of the limited services that are available. So emergency healthcare is something that we still need to look at, not only from a COVID perspective, but from a perspective of how do we make that extremely operational. And I just want to end where I read an article where someone was saying that the moment we hit 1,000 cases in Kenya, those cases would not be able to be sustained by the healthcare system. And so the whole goal is to try and see how do we get to less tests, how do we get to less cases, and how do we get more people tested? And that goes back to the oxymoron of we don't even know how many test kits are available. We don't know how many people have been tested. And that then makes it difficult to know, are we actually winning the fight against the virus? Because only locking people down, only putting curfews without having the testing measures in place makes it very difficult to fight the virus and be triumphant as we need to be.
Okay. Thank you very much. I appreciate your response, and thanks everyone who's joined us. That was our final speaker. He's Alan Maleche from Kelin. And so I would want to ask if anyone has any questions. We have the app, and maybe I'll ask Sumaya and Kate to have that, the link shared on the chat. If you're on the chat, you could just go to Slido, sli.do. The hashtag to use is COVID-19 law, LAW. If you post your question there, we'll be able to handle it. And so I'm going to ask our speakers. We have Alan, we have Maria Beneka, we have Linda Wambani, and Declan Magero. So we'll go through a few of the questions. You just unmute your mic and answer to them that refers to you. Somebody's asking Declan to elaborate on the product-based approach. How can lawyers use the product-based approach to ensure that they get more business even in this particular season? And I like what Declan had pointed out around public goods. How do you still take care of people in this pandemic, even as a lawyer, and not just be about the bottom line? Somebody else is talking about National TB, Leprosy and Lung Disease Program, isolation policy. It's only limited to those three. And so maybe you let us know, Alan, if if we lack a policy around isolation for patients. Someone else said the stigma in messaging on COVID-19, does this amount to discrimination? The government, we have people who committed suicide because they're too scared to come out, are we stigmatizing people with COVID-19? Someone else asked, how can firms balance between employee rights in the sense of salaries and benefits in such periods of reduced revenue, taking into account the indefinite time? So Maria, I think you could tell us about that. Maria, why can't we get an e-account at the time of renewing your practicing certificate? Judiciary has been delaying this whole IT issue. Somebody else, Olivia, says Nairobi to Lagos on breaking geographical boundaries. The challenge is lawyers often have restrictions on the jurisdictions they are qualified to practice in. So if I can't practice in Nigeria, Declan, how do I practice in Kenya? So I think you could handle that. Somebody asked about markets, new markets that relate to public goods. That's for Declan. We have someone from Parliament who says, what could be your thoughts on how parliaments can operate without physically meeting and yet be able to discharge their constitutional duties? I think this also is in reference to what the president announced yesterday on the different economic interventions that government needs to do. These are supposed to be passed in parliament. As we know now, parliament is in recess. How do we again have parliamentarians meet electronically? Mwago asks, what kind of cyber risks should lawyers watch out for as we switch to remote work? And I'd want to ask Lawrence Abel, who's also on the call. He's a cybersecurity expert. He can speak to that at the end. What tools do you use to monitor performance? Granted that we expect that productivity will definitely go down, So I think anyone who can answer that particular question, please answer. Those are the different questions. Somebody asked, Olivia asked, Maria, how do you have support staff like clerks? How do they work in such a situation? Because clerks are basically, can they work online? What do we do? Mutugi Mutegi asks, what solutions would lawyers without consistent, reliable access to good quality internet use? Meneka mentioned USSD solutions. What are the other alternatives? And then there's a question on data protection as well. What do you think about the concept of data protection while using shared network as employees work from home? And Clinton, how do startup law firms get to clients during this COVID-19 crisis? In Kata Kitinji, we had handled the issue of scale. And Mutugi says, is it possible to speak to the possible nuances, different practice specializations in the legal profession face? E.g., the commercial lawyers are very different from conveyancing and from litigation. The final question is, how will law firms be able to guarantee client confidentiality and proper cybersecurity when employees are working from home? So I think we'll answer those and then we can get to another round of questions. If you want to ask a question, go on Slido, sli.do, and use the hashtag COVID-19 law. So I think my panelists, we can begin in what order? Maybe from Linda.
Okay, can you hear me?
Yes, we can.
So I'll take the question on how startup law firms can get to clients in the advent of COVID-19. For me, I think social media has become a very good platform within which to get referrals in terms of clients. So startup law firms, if you're able to give at least a fast free legal advisory on any of the legal and risks that can affect businesses, that's a way for people to know that you're actually available and able to give a service. And you might even get people signing up on your social media platform and requesting for services outside the social media platform. Another way is to be able to contribute to discussions around the legal impact of COVID, as we are doing today. So if you're a startup law firm and you're able to get into the webinars that are going around, that's another way to market your law firm. Writing in the digital newspapers like the Business Daily. Those are ways within which you can be able to be able to get visibility and be able to get into legal work. Thank you. Hello, Linda. Have you heard me?
Linda.
Hello. Hello.
Oh, yes, I can hear you, Linda.
Yes.
Sorry, I had a question for Declan. Victor Mulindi is asking, how do we restructure our firms to meet the expectations of this online working from home age? So I think we'll have Declan next.
Linda, for clarification, I'm not sure, should I answer this particular question directly or go over some of the ones you had earlier mentioned?
You can go through all of them.
Okay. Yeah, so I think one question was on product approach, a little bit of clarification on what product approach means. So technically, a product is usually an end-to-end or an offering that has an end-to-end approach to it. And the challenge with law as an industry is that it tends to be really, really complex. So I believe a product design approach in law should be to make offerings as simple as possible and as scalable as possible. I think the lawyers need to do something called how do you design a legal product, some hackathon or something to help law firms really understand what is the process of developing a legal product. Usually when, let's say tech startups, and I think law firms can learn something from tech startups here. When tech startups are starting out, the first question they ask themselves is, what are we offering to the market? And they start by designing this particular product. I think law firms start on the other side, you know, and the challenge with law firms traditionally is, of course, it's a heavily regulated sector, and you have things like advocate remuneration order that defines to you already like pricing points and things like that. I think it's time that lawyers, and this will potentially answer the other questions, lawyers challenge this particular, let's say, regulations. Because if you have a market that has already defined for you, technically locked you within a certain playing space, it offers a critical challenge on how do you get innovative and potentially grow. Well, the good news is highly regulated markets traditionally tend to be also markets with the best opportunity in terms of disruption. So this is a good chance for lawyers that think differently. I think markets is a public good, or markets and public good. I think this also ties up to the whole question of product. If you start by asking yourself, what are you offering the markets? Then it's very easy for you to be able to potentially target a public good as potential market. And if I go back to the question of pensions and 10% of pensions as a requirement in terms of investment to venture capitalism and private equity, that means you as a law firm or you as a lawyer can actually design your practice around, you know, this 10%, which is a lot in terms of value. And I was just doing my research to find out if anyone has placed a number on the legal industry in Kenya or legal market in Kenya. And actually in 2016, there's a number that the legal market in Kenya is worth $3.2 billion. What does that actually mean? As a law firm, how much of that market share do you control? Have you done the math? Have you ever even thought of doing that kind of math? So I think it is in opening up this mindset that lawyers will start looking at potentially public good as a market, as opposed to just what is regulated and recommended by authorities in law. I think the question of restructuring your law firm to be able to deal with current challenges, to be able to scale and be different. I think it's actually possible to not necessarily restructure, but to adopt innovative strategies that will allow you to potentially get going in different markets. And one way could be targeting non-traditional industries that most people haven't ventured into, and crafting some type of products, if you follow the designing legal product approach, or crafting some service or practice that is extremely unique but highly needed. A quick simple example is, for instance, we have a proliferation of startups in Africa, globally actually, but in Africa, for instance. From someone who speaks to quite a bunch of startups, I will tell you that startups need a lot of legal services, but they do not know where to go. If you were a law firm that would simply target startups as a service, that would actually be something that would make sense in terms of, can you size that market up? Can you conjure that market up into numbers? Can you make some kind of turnaround around that? I think it's highly possible. It's not super innovative. It's almost lazy, but it's different. So it's very, very possible in terms of strategy, but it's even possible in terms of just restructuring by challenging the traditional regulations that are already there. And lastly, I think practicing in different countries as a law firm could be done in two ways. One is technically just being able to have so much capital base that you can open law firms across the region, but this is sort of a traditional approach. I think most law firms that have this, that think of scaling, do not necessarily have the funds to do that. So that leaves you the alternative to, again, be innovative. For instance, if I refer back to a product design approach, then that means you can actually design a product that can be offered beyond one jurisdiction, like the startup product, for instance. There are startups all over the place. So you just need to adapt your product to different jurisdictions, and that actually lets you grow in various markets and be relevant to the day and times. So I hope I was able to more or less capture most of the questions. Thanks.
Yeah, thanks, Magero. I think from what we hear is that we must innovate and reinvent around the work that we are doing. And I see some legal tech startups that already working in this particular area. They are, making forms online, having people go online in that particular case. So at this particular level, at this particular time, I want to ask Maria to join us. Maria Beneka, I'll add you maybe 2 questions. We're taking questions on Slido. So if you go to sli.do, you will get the questions. You can ask the questions from there. Somebody asked, just a minute, somebody asked, in view of the abrupt closure of the lands office, how do we handle delays in transactions caught midstream, force majeure, the doctrine of frustration? How do we get this going? And someone else asks, they have accused persons in custody, they are unable to reach their counsel. How do they come against fraudsters in this particular issue? Because some people will call the prisons and say, I'm a lawyer, yet they're not. We have a few questions on YouTube as well. Everyone who's following up on YouTube, thank you. John Chikiti, advocate senior, he is asking about clients who want to meet their lawyers face to face. They say we can't give instructions unless it's face to face. How do you do that as a lawyer? Thanks everyone who's posting on Slido. Thank you.
Thank you, and thanks everyone for these brilliant questions. On this issue of the lands office, definitely I feel that the lands ministry took advantage of the pandemic because remember we had to go to court to force them to reopen the registry. And now we're back to the registry not being open because of the pandemic. Definitely now in the prevailing circumstances, we will not have a choice but to claim force majeure. But falling back on our litigation, wherein we have orders, I think we still need to pursue the opportunities that exist. And I think I remember not too long ago, the President Harvey going to a meeting with the CS Lands and the team. I'd be keen to know what was agreed by the President and the team, because they cannot claim force majeure at this time where a lot of these transactions are stuck or pending, and yet we have now most recently through a press conference or statement or directives by the President of the Republic of Kenya saying that money has to be unlocked. And how will this money be unlocked if it is tied to transactions that are being held in abeyance by the Ministry of Lands? And yet we have a team that is called the team of ease of doing business. I think that team should move quickly. We also have a judgment. The Law Society filed a matter against the KRA where we were being compelled to pay CGT prior to the transfer of the property. That process is long and tedious. So there's opportunities by the LSK. The council now has a lot of work in terms of ensuring these judgments are actually enforced and the orders are enforced. And especially now that the KRA has more or less fully automated, these are some of the things they should be able to help us with. The Lands Ministry, I believe that's the bigger delay in terms of where the transactions are getting stuck. The other question on fraudsters, this is an issue for, I believe, the LSK as well to get on with the digital registration of the members. We already have our database of all the members. All we need to do is migrate that to a digital platform where we can verify, and perhaps this will require a sharing of data between the NCAJ players, that is the judiciary, the prison services, the ODPP and the judiciary, and any other, perhaps even the AG, so that they can verify the identity of our members. This is an opportunity as well for the judiciary and the prison services. You've seen the proceedings that have been carried out in the open due to this COVID-19. You've seen criminal matters proceeding where bloggers and medical practitioners who've been charged with some crime or the other, proceedings happening out in the open. Now it's an opportunity for the judiciary to create perhaps open and bigger, bigger courts, and even provide screens so that the judicial officer does not necessarily have to be in the same room as the accused, and even provide a room for advocates to confer with the clients. If you think about some of the smaller issues, such as the advocates lounge and areas where we roam, now that we're thinking about hygiene, public hygiene, and not transacting or contracting this disease, we need to be very careful about how we proceed with public spaces now, especially when it comes to our practice. So the prison services, the judiciary, opportunities for them now to create long-term solutions that will allow advocates, and even in police stations, how will we be able to meet our clients, for example, without exposing either the client or yourself to any of these current issues. But going forward, we definitely do need meeting rooms where you can speak to your client with confidentiality. There was a question that I had seen, I think, on the YouTube page about, there was a question about persons with disability and access to this technology. And in the practice directions that I have shared on the platform, you will see those practice directions. I have quoted, let me just quote, I think it's practice direction number 10, exception from e-filing requirements. And these exceptions can be granted by the court in exceptional circumstances, and especially in areas where persons don't have access to either the internet, or by virtue of disability, one way or the other, are unable to access this particular form of accessing justice. So this is something that the judiciary will have to work on progressively. I would want to commend CJ Maraga and the team at the ICMS committee for actually getting this started. It took in a lot of work. You'll see from the documents that I've shared. We considered a lot of the things, and I think there was a question that had been asked earlier on Slido about the e-accounts. Yes, these are basically an email account, and what will happen is that each firm will register an account, and in the law firm, you will also have to register the persons who can file and upload documents on behalf of the firm. So what will happen is that this will also curb quacks and people who are impersonating advocates, so that if you're not an advocate, or if you are not a qualified officer of the court, such as the court process servers, then the court will be able to zero in on such persons. But remember, members of the public also have the right to file documents. So this will mean that the advocates still will have to think about how we handle our matters efficiently, and what kind of additional services we provide to the public. Because currently, the more we digitize, the more there's access to the judicial services to the public. So what is it as an advocate that you'll be providing that will set you apart and offer services to the public without necessarily losing your income?
Okay, thank you, Maria. And we'll go to the final question to Alan Maleche from Kelly. I've seen several more questions around who takes care of health insurance for COVID. If I'm sick, and the insurance companies are bailing out on us. What do we do? And that takes us to, are we reading our insurance policies that we get? And two, somebody else asked about restrictions to access to information in this particular time of emergency. Is there a higher threshold within the Constitution? And thanks everyone who's sharing the links to the work that Kellen is doing. There are particular cases within the particular cases that are being highlighted on Slido. So just go on app.sli.do, sli.do, and use the hashtag COVID-19 law. You'll be able to ask questions on that platform. And I think on YouTube as well, there's several questions. We'll be able to get to them as Alan gives us his final comments. Alan.
Thanks, Linda, and thank you so much, colleagues, for the interactions. Your questions are very useful and quite helpful in helping us learn about this. I'll start with the first one that spoke to the fact that the isolation policy I'm talking about only caters for tuberculosis. I think when you have a look at the judgment, you'll realize the policy was developed as a result of a challenge to the public health law to determine what is the contemplated place of isolation and how do you do isolation in a way that still respects the constitutional rights. So my view is that even though the policy is specific to certain diseases, it could still be adopted to the COVID situation because the standard setting of an isolation room do not differ irrespective of the disease. So again, we don't need to develop a policy for COVID on isolation, but we can adapt what is already existing. But what I'd want to point out from a lawyer's perspective is to realize that an order was made in 2016 by Justice Mumbi to have this policy in place within 90 days, and thereafter for each county to have an isolation policy and also have an isolation place available. But it has only taken the COVID virus to now see that counties and even the national government are rushing to put up isolation policies. But had they obeyed this court order in 2016, would have already had 47 isolation facilities across the country. So this goes back to the rule of law and how then do we ensure that we push government and the executive to respect court orders because they then have consequences on the health and the life of the people. I think the messaging that makes it appear that a person who has any virus, be it HIV, TB, or COVID, to be a criminal is one that instills not only fear, but can drive people to be subjected to mob justice, can drive people to die of self-stigma, can drive people to be able to commit suicide, whereas you may not have a direct causation of your death and stigma, and hence have to litigate on it. But these are some of the social challenges that require our leaders and those in positions of power and those who are communicating to be sensitive to the kind of the information they're able to take forward. We had a question about employers' rights vis-a-vis salaries. I think that's a tough one. And again, these are some of the breakthroughs we are hoping the government would be able to step in for different employers to see if an employer relies on certain income and the income is not coming through because of COVID, what does the government have to do in order to be able to reach that perspective? I do know of countries like Denmark that are taking about 75% of the pay costs from employers. People will argue that Denmark is richer than Kenya, but I'd also argue that Kenya is more corrupt than Denmark and we lose more money in corruption that would actually be able to cushion employers and other people in formal settlement to be able to address this. In terms of restriction of access to information, my view is that there's not a higher standard needed. We already have the constitution that spells out what happens when you need to limit human rights and you need to follow that. And then you have the Syracuse principles, which come as a result of the International Covenant on Civil and Political Rights that says factors that must be taken into account in terms of limiting rights. So I think for now, unless the state or the governments can demonstrate why certain basic information is not relevant for citizens, then we work with the assumption that all information should be made available. Now, in terms of insurance companies, the argument is that the government right now is providing all care and treatment related to COVID. So the insurance companies are claiming that their role is to deal with any other issue outside COVID because the government has already put a mechanism in government facilities. So many insurance companies are arguing that their role is to try and get to those government facilities. And then once you're there, the government then takes over your treatment and control. because this is a national emergency, and so the national government is taking control of this particular issue. I haven't heard of cases where insurance companies have declined to provide other health services, but that may come down in the line, and it's something we need to be able to explore and see how do you anticipate the insurance companies' contracts and what they look like. And I speak knowing that we have got both who represent the clients, but also those who represent insurance companies. But we must then also appreciate how then do we make the right to health more accessible and not only use insurance clauses and policy to limit the ability of Kenyans to be able to access that particular right. Thank you, Linda. I hope I've not missed out any question. If I have, I'm happy to go over it. Linda, you're still muted. We can't hear you.
Oh, sorry. So now you can hear me. I will. Okay. I'm being asked to look at the camera. I'm so sorry. So we'll take the final comment from Lawrence Abel. Lawrence, if you can hear me, he's a cybersecurity expert, and we have done a few of projects together at the Lawyers Hub. Lawrence, can you hear me? You can unmute your mic and just make a comment on cybersecurity. Lawyers are wondering, how do we still maintain the privacy and confidentiality of our clients' data even as we work from home? What tools can we use? Lawrence, can you hear me? Okay. Sorry, I'm unable to find Lawrence. Okay. So I'd maybe just refer to what we had initially talked about, the use of VPNs. I personally use NordVPN, that's N-O-R-D VPN, and I'd encourage you to pay for technology. If you're able to pay for VPNs that will enable you to, other than watch things on Netflix that are not available in Kenya, but also would enable you to protect your client's data. We have an annual rating of VPNs that's done by the privacy professionals, and we can also sort of bring in we can provide this particular rating on the Google document that we are co-creating. If you took any notes during this session, we have a Google Doc, and the link was shared to the attendees. I think we'll share that as well on YouTube, so that we're able to come up with a good document from this particular discussion. Leah Kigwatha, advocate, says that there's an American lawyer who's written a great article. She's shared the link, and we'll be able to share this notes after we are done on how you can go virtual very fast. I think that's useful. So I'll take the final sort of, ask our panelists to give us the final comments in light of two things. Somebody's asking, how do lawyers remain relevant when technology seems to be taking up a lot of the work that we used to do? And I think that's Alice. Someone else says, tech has the potential to shift the legal profession to be people-centered rather than the current service provider-centered approach. So how do we do that? So I would want to ask, okay, we lost Maria for a moment. So I just want to ask our panelists to give us the final remarks. I am sorry we were unable to take your personal questions unless on the platform, because there's so many of us on this platform. So next time, let's continue to use Slido. We hope we'll have more time and also increase our reach, because we're unable to have everyone on the call. So I'd start from Kellen. Alan, it would be important to talk about the link between tech and policy and everyday policy. We may not be concerned about HIV/AIDS and the law because it doesn't concern us, but it's actually important that we engage on health and the law. And COVID-19 reminds us that we have a duty to engage on these intersections between law and several other disciplines. What are your closing remarks?
I think my closing remarks are that lawyers remain relevant to this particular discourse and the fact that technology brings various challenges. Lawyers remain relevant in the extent that there are laws and policies that will be developed. They will need legal minds to be able to craft that. The laws and policies have to be interpreted, and the laws and policies will be subject to litigation or challenges before courts. And so as lawyers, we need to be able to be abreast with some of the developments of the technology, but also appreciate how the technology is affecting either rights of our clients, either business transactions of our clients, or elements that make the lives of our clients go from a day to day. So for me, I believe we still have a role And most importantly, in this current situation, our priority should be ensure that we win against the virus, but in doing so, we ensure the rule of law stays and that rights are not trampled upon. And that squarely falls on us as lawyers to be able to stand out and speak out to avoid any limitation of rights in a way that does not comply with the agreed laws. Thank you for having me on board.
Thanks, Alan. Linda Wambani from Skyrim.
Yes, thank you, Linda. I would say lawyers remain relevant by going into new areas of the law. There are various new upcoming areas like data protection, e-commerce, data science, artificial intelligence, where legal services will need to be provided around that. But for them to do that, they must be ready to learn new skill sets. And to be able to do that, there are a lot of online platforms giving free courses on that, like Udemy and Coursera. So I would just say that lawyers need to be ready to unlearn old ways and learn new skill sets. Thank you.
Okay, thanks, Linda. We appreciate. Maria? We lost Maria for a moment. I hope we can find her. Maria, you can hear us?
Yes, I'm here.
Okay.
Yeah, sorry. So these are closing remarks, Linda?
Yes.
Well, basically what I can tell lawyers is that we don't have a choice but to innovate. And you know, innovation is here with us. Now we have, I know not many people were happy with the pronouncement on the 4G loan, but it's an opportunity that we need to take advantage of. It's presented itself. We really ought to take advantage of that and automate. It's, you know, given now where we are, having to work from home, you've seen why it's important to automate. So you can pick your files from wherever you are on the go. You'll be able to communicate with your clients by email. You don't have to physically go to the office. So that's the first thing, automate. It's about time. Secondly, we need to explore new areas of practice, not just litigation, criminal or civil. There's mediation now that's come up. There is, you know, arbitration. You know, all these areas of practice that lawyers haven't quite gotten onto. I know artificial intelligence is not something many of us have embraced. It can help us in being efficient, you know, have smart contracts and, you know, improve your efficiency at the office. So we need to take advantage of that. And then we also have to look at other areas, you know, in the commercial transactions, in IP, in entertainment law. I get a lot of queries on copyrights and ISPs, and all these are areas that are emerging. Let's follow the market, really. As lawyers, we have to study our clients. We have to look at data. We also have to agree to, you know, have our data published in the economic survey, because if you look at the economic survey today, you see that legal services only covers what the judiciary is offering. So how many cases they've disposed, how many people are in jail, but what about the advocates who provide those services? We are not quantified, and therefore we do not, we're not visible when it comes to the economic forecasting in this country. And therefore legal services will keep being chopped if we're not seen as an essential service. And that's why even you see in the list of ease of doing business, legal services is not a priority. Actually, when government is thinking about efficiency, they think of removing lawyers from the transaction. So we have to renegotiate our space and make sure we're at the pole position in terms of offering services. Legal aid is something advocates need to look at critically, because in as much as it doesn't appear appealing in terms of billing, it goes a long way in you know, improving our understanding of what the public first is grappling with, so that you can understand the issues. And then also as part of our CSR, but it's an opportunity for many of those who've come into the profession to hone their skills and provide, you know, a basic entry level for younger advocates who are getting into the profession. So there are very many opportunities. There are apps which exist out there. There are other jurisdictions such as Scotland and the UK have adopted various applications that help improve efficiency for the law firms. Specialization is very, very important for advocates. It's no longer business as usual. You can't do each and everything and expect to, get somewhere. It's about time we picked our niches. If we've not, I would encourage highly that we get to that point where we're actually specializing.
Okay, thanks, Maria. And the final speaker, Declan Magero.
Thank you, Linda, for having me. Some quick remarks. I think what COVID-19 has probably taught law firms is this disease of everydayness. The sun is going to rise and it will set, and sticking with good old ways of doing things. But I think the wake-up call is, hey, we need to do things a little differently. So I think my recommendations include, one, law firms and lawyers must innovate. They must innovate consistently and challenge the status quo. It is quite interesting that, the market is heavily regulated. A lot of things are already cast on stone or set. So I think this is what lawyers need to challenge and go beyond, this restricted, regulated space. Most companies that develop across the globe actually are ones that challenge the status quo. I think the other thing is law firms must think of themselves as product companies as well as service delivery companies. So they need to focus on designing legal products, and they also need to focus on designing service delivery processes. In this way, then they're able to capture the market, and they're able to translate that into not only numbers, but also efficiencies. I think the third thing is data. Data is critical, and Maria's alluded to that, but I'd like to emphasize the reason why, lawyers and legal industry is not, legal services are not viewed as critical services because people do not necessarily see what they offer, and people do not necessarily understand. But for me, how I translate it is every single transaction, every single exchange is a transaction, and that's technically should be captured in some form of legal processing. So that means lawyers are generally very, very important. And this is a very, very important industry because you're able to ensure that, people can access justice, people need their rights, well taken care of, etc. So there's no way that somebody should view this as non-essential industry. So I think data is one way to ensure that this is actually well captured. So lawyers, law firms need to publish a little more on not only the traditional sector, but even the non-traditional areas. They need to come out and show us demonstrate a little more. Just the way fintech, for instance, is all over the place, flaunting every number about something. I think lawyers also this industry needs to go that way. I think these are my remarks, and thanks very much for having me.
Okay, thank you very much. So we had from Linda Wambani from Safaricom, Maria Beneka, who's a council member at the Commonwealth Lawyers Association and the immediate former convener of the ICT Committee of the Law Society of Kenya. Kudos on the good work that you have done thus far. From Kelin, we had Alan Maleche. Thank you for your remarks and for your comments. I think this was pretty useful. I want to thank all of you for coming for this webinar, and I want to encourage you to engage on policy, because COVID-19 just opens up our eyes to the gaps that exist in our health law, gaps that exist in emergency healthcare, gaps that exist in access. Everybody's home now. Do we have internet? How do we expect people in the rural areas to, continue schooling, to, watch television? Do they have electricity? I think as lawyers and the justice sector, we have a role to play to ensure that these things are mainstream, that the cost of internet goes down, the cost of electricity goes down. That way we are able to get on online platforms as well. Also that we engage on the budget process, because when we get more money, the judiciary gets more money, the justice sector gets more money. It means that they can do more and they can actually get online a little more in this case. Finally, I'd want to just say thank you from the Lawyers Hub. I'd want to commend the team that has worked to get this together. Thank you. I may not mention you by name, but I want to thank you. We have posted a little bit of the links that we have on YouTube, also on Slido. We have a Google document that we have put together from this particular discussion. Please contribute to it because it's open source, and we're able to have further discussions once this is done. So we're not going to end the call at this point. I just want for the participants, you can post a little bit about yourself on the chat section, get to know what someone else is doing. We'll do a little networking for maybe 5 to 10 minutes. Please post about you. If you have a product, for example, I think it's called Munga. They have online forms that you could fill to help you, through your process as a startup. If you want any of that, please go on the chat and just post a little bit about yourself. We'll be happy to hear from you. I apologize to anyone who wasn't able to join us today. We tried to upgrade the number of people we could have on this call, but it takes about 24 hours now for Zoom to make those changes because everybody now is on Zoom. So we want to promise you that the next webinar will be way better, and we'll have more attendees as well. Thank you for the over 110 people who joined us in and out of the call. We want to thank you so much. Our next webinar is going to be on startups, and if you're looking for legal support for your startup in this particular season, we'd want to get in, to do the public good that Declan Magero has pointed to, and we want to ensure that lawyers actually are part of your conversation and part of your growth as a legal startup. So invite your friends, ask them to sign up on our website, lawyershub.org. And if you're a lawyer and you want to be a member of the Lawyers Hub, it's easy. It's going to take you 3 minutes and 2,000 shillings. If you go on our website, you'll click, I think twice or thrice, and you'll be able to join the Lawyers Hub membership. I think we have, spoken, somebody's from the UN and representing the humanitarian practitioners. Thank you for joining us today. I don't know how to end this, but just to say thank you so much. We'll put off the video and go on mute, but let's continue to interact on the platforms. We have some links that were shared on Slido as well. For those who want to, get to read on everything, we'll be able to share that to our attendees who registered on Eventbrite. Thank you very much. And Nana, thank you. I've seen your baby come in, food come in, pets come in. Thank you so much for joining us despite, all these distractions. We sincerely appreciate. And with that, bye everybody, and thanks for joining the Lawyers Hub. Yes, it's so hard to leave. Bye guys.